Hey, good morning, guys. So today we will start our general paper. Just briefly go through the syllabus and then since if you guys have any questions, you can ask in the chat box, then I will answer accordingly lah. So I think you guys will know, right? For general paper, we need to answer two questions. So the first question will be contract, and the second question will be the top lah, right? Okay. So in general, but I cannot say every time, the each question will be divided into part A, B, C. Okay. So the part A, B, C, for part A, usually they will ask what is the cross of actions and any defense. This same applies to contract and also tort. So for example, they will give you a fact, then they ask you to advise what are the cross of action I can sue for this contract, I can sue for the tort. Okay. For part A, I think compared to LLP, actually CLP will be easier is because they won't ask you until like so details, like or do you think the critical examine the breach of contract, how to form the contract. For example, if you guys remember those like postal rule, if I send a letter to you before you accept, I also post another letter to revoke the offer, something like that. No, but for CLP, actually, it's pretty quite straightforward. For my observation, usually they will only ask for a few perspectives lah. For example, they may ask, there's a negotiation, offer acceptance, counter offer. Then if the question never clearly tells you that there is a confirmed contract, so you may need to discuss the formation of contract. So what is the formation of contract? So you can discuss it's like offer, acceptance, consideration, capacity, and also intention to create legal relationship. I just quickly share that. So although to form a contract, there's 5 elements, but in general, we do need to discuss the capacity and also intention to create legal relationship. So why? Because in usual questions, unless the question tell you the party enter into a contract is a kid or is a minor or who doesn't have a capacity, then only you need to discuss about the capacity. Otherwise, in general, we will assume everybody have the capacity to enter contract. Even you want to write also, you will just briefly write to say they have a capacity to enter. So this is the first one. Second, intention to create legal relationship, which means in general, in commercial contract, usually we will assume the party will have the intention to enter this relationship. The exceptions is where is family contract, because the law is says that in general, we will presume everybody, when they do a contract, they have an intention to enter into a contract, except family. Why? Because let's say your mom asks you, hey, can you help me to clean the house? You cannot say there's a contract. You cannot say I want to sue my mother. So in general, if the contract is a family contract, the court in general will presume there is no intention. Other than that, usually will have intention. So understand? So 5 elements, usually we only need to focus on the 3, which is offer, acceptance, and consideration. The other 2, unless the contract mentioned is a minor or mentioned is a family contract, usually you don't need to discuss. Okay. So I give you a scenario when you need to discuss the formation of contract. So if the passive question they are telling you is like, oh, I wanted to buy a land, I offered to buy a land, then the party like negotiating but never sign a contract. Then this kind of situation, you may need to discuss the formation. Why? Because certainly they will say, there's no contract, why can you sue me? So then in that case, you need to see whether there's an offer or ITT or counter offer. Okay, later we can show the questions up. This is the first type lah. The second time is they will straight away tell you there's a contract. For example, oh, I buy the house from a developer. The developer promised there's a CCTV, there's a security, but turns out there's none. Then you can sue them for misrepresentation, fraud. Okay. I will quickly go through also what is the differences between voidable and void contract. So voidable, as you know lah, every time when you write English, ABLE means like may or may not. So voidable means like can void or cannot be void. Void is like no say, straight away void. For example, you're selling a drug. You cannot say, hey, willing buyer, willing seller, I want to sell a drug, you're willing to buy. No. Some contract is straight away is void one. You cannot say willing buyer, willing seller one. So that one is void contract. Voidable, on the other hand, is like you still can choose. For example, I enter contract with you. I tipu you. You can choose to continue or you may choose not to continue. Go back to the original position. This one we call rescissions. So let me repeat. If your contract was ended by coercion, which I force you. Undue influence, I keep influencing you. I tell you, this is the best, this is the best. Or fraud, or misrep. In this four situation, you can choose to affirm, which is you want to continue, or rescind, go back to the positions. Okay. But on the other hand, if it's a void contract, then Lansong cannot be enforced. It's void. You cannot deem is a formal contract, valid contract at all. For example, mistake. For example, unlawful, like the drug I saying now, and receipt or trade. Let's say we enter a contract to say, you cannot sell property, only I can sell. Cannot also. But of course, there's exceptions. Okay. So let me see. Okay, there's a question asked. The corruption will redeem the contract void or voidable. Okay, good questions. I think you refer to one of the past questions to say that if I remember correctly, there's a government project and the party wanted to get the project, so they pay to the B person to get the project. Okay. From that contract, my interpretation is that I pay this person is to get the project. Okay. But is this conduct, let's say it's an agent fee or consultation fee, is fine. But if you, let's say, you pay under table, no receipt, all that, then that one is corruption. Then that one is void contract. That one cannot. So I would say it depends on the context. You pay for what purpose? So in that case, if I'm not mistaken, we are representing the company. The company pay to B to get the consent, to get the project. And I wouldn't argue that one is a void contract because if you argue it's a void contract, isn't it? You are telling the court, your client is Lasua B. So I don't think we should say that, if I remember the facts correctly. Okay. Then I think a lot of people, they don't understand what is the difference between rescind and also terminate. Okay. Let me explain. I always make a joke about this. Rescind contract is like you get a girlfriend for online. So let's say actually this girlfriend is not as pretty as she described. Okay. Then when you enter relationship with her, when you face to face, you meet up her, turns out actually she's not as pretty as she say, or she tell you all the background is wrong. Okay, in that case, it's fraud and misread, right? Then you will try to say, I want to break up with you. I want to rescind the relationship. So when next time people ask you, hey, do you have a girlfriend before? You will say no, which means you don't recognize this girlfriend at all. This one called rescind. Okay, but termination on the other hand is like, I got a girlfriend, we parol, we dating for quite some years, and then after that we break up. Yes, when people ask me, do you have girlfriend? Yes, I have, but I break up already. So you see, termination is like, I recognize the past, but from now onwards, I don't recognize already. So this one is breakup, is termination, which means I recognize last time we are couple, but now no more. But rescind on the other hand is like, when people ask you, you say, I kena tipu. This is not my girlfriend at all. So this is a different. Okay, another question. Can it go under illegality when it comes to corruption? Yes, I think corruption is under unlawful category. Yes. Okay, so this is the differences between void and voidable. Then next one is like discharge, as in like in what situation we can say, oh, we deem the contract is completed or we discharge the contract. Okay, so the discharge can be go into three categories. One is like frustration, as in like we never complete, but it's because of something happened. I think most of you should understand what is frustration. I just quickly explain. Frustration is like something unusual happen within we cannot perform the contract. Okay, so for example, last time we can wear baju kuning, the yellow shirt, but because of per se, so suddenly we cannot buy already. It redeemed the whole situation until I cannot perform. But again, must remember frustration, we have three requirements. Number one, it redeemed the contract impossible and unlawful to carry out. But please take note, the unlawful here is not the same as the unlawful under section 24. Why? The unlawful under frustration must be unlawful after you enter the contract. If the thing at the first place is unlawful, which means let's say you're selling drug, originally you are not allowed to do so, then this is not unlawful under frustration. The frustration must be a supervening event, which means it can later become unlawful, like baju kuning. At first you can sell one, but later on you cannot sell. Okay. So, and some more, this is not shouldn't be something because of you cross thing happen. For example, I sell baju kuning, then I purposely go and say per se, so that I cannot sell baju kuning. This is my fault, then I cannot use frustration. Okay, right? So this is the first type, how you discharge your duty. Second type, performance. Let's say you perform 90%, 50%, You never complete the whole thing, but you may argue lah, I perform halfway. I think this one also applicable to those past year question like, I do some work but never complete, can I claim some money? This one we call quantum merit, as in like I do halfway. Is it okay for me to claim the money also? Never complete by right, logical sense, you should complete, then only you claim. But because some reason, let's say, especially constructions, you cannot say because I complete the whole house already, because the piping got problem, you don't want to pay me a single cent. Cannot. At least you pay me what I deserve. Okay, quantum merit. Okay, I saw the question. So if there is a rescission, there is a way section 66 restitution, go back to position before contract started. Yes, 66, yes, restitution, go back to the situation, original position. For example, I pay you money, you give me the book. So when we go back means you return me the book, I give you back the money. Okay. Then breach. Okay, breach is the famous contract famous chapter or famous question will be asked in the past year questions So like I mentioned earlier, if let's say the people promise you something already but they never perform, then you can sue them for breach of contract Okay, always remember what does it mean breach under section 40 is refuse to perform and disable himself to perform. This is breach of contract already. In that case, we still need to further determine the breach is fundamental or less important. Why I say so, sir? So I give you a scenario. I build a house. I give you the house already, but it may be the toilet, not what you want. So maybe this is not so important, right? The overall, the entire house still okay. But you cannot say just because of the toilet, you don't want the whole house, you terminate at the entire contract. So in that case, you can only continue and ask for damages. So for example, if I give you the toilet that cantik, not nice, not what you want, you just ask me for compensation, no? But if let's say I promised to build a house for you, but I didn't build at all, in that case, you can choose to continue or terminate. You say, I don't already, right now I don't trust you. Okay, so this is the differences. You must differentiate the fundamental and less important. Okay, so affirm and terminate, there's no right wrong answer, because I think some student will ask me, hey, then should I choose affirm or should I choose terminate? I think it depends on the facts. If let's say the contract that tell you I want this land, I invest so much on the project already. If I now I call off the deal, I will suffer loss, then yes, you advise your client to go ahead. But if let's say they only suffer monetary loss only then you can ask the other party reimburse to you then you just terminate and ask for damages But again, for me, there's no right or wrong unless the question tell you so clear they want this contract badly. Then you advise them to affirm to continue. Okay. Then another thing they like to ask you is the damages So again, damages can be good to pecuniary and non-pecuniary. Pecuniary is like, as the title suggests, is money. I want money. And non-pecuniary is like non-monetary. Okay, let me explain one by one. Monetary, I think, simple I want money. So what kind of money? Expectation loss or reliant loss. Okay, what is expectation? I expecting to earn some money. For example, I say, if I enter this contract, I can earn million. Okay. So when you breach a contract, I cannot earn this million. I expect in the future one. This is expectation. Reliant loss, and on the other hand, is like, because of this contract, I spend the money. For example, you guys say, hey, right now, teach me CLP, I will pay you. Then I say, okay, I will teach you CLP, I will go and get a laptop. Okay. Because of this contract, I go and buy the laptop. I rely on the contract. I spend some money. This is reliant loss. So what we can see in the past question usually will be like, legal fee, valuation, or SMP fee, something like that, stamp duty. Okay, this is reliant loss So remember, expectation is you haven't suffered loss, but you're expecting to earn in the future. Reliant is like, because of this contract, I spend on this contract. Okay. Okay, on the other hand, non-pecuniary is like non-monetary. I don't want money. Why? Okay, I want money, but my losses is not money. My losses is like I stress I'm not happy I'm mentally distressed humiliations Okay. In general, non-pecuniary is not claimable is because the court don't know how to determine, how to quantify. For example, you cannot say not happy 1 ringgit, sad 3 ringgit, cannot, right? So in general, the court is reluctant to give, okay, in general, because contract cannot buy emotional, okay. But unless the contract do says, let's say the contract is for happiness, for holiday, then maybe you can claim, because the contract purpose is to make you happy, So when you breach of the contract, then you can sue okay. Then Before you wanted to say, I want to claim the money, you must satisfy two things. Number one, causation, which is my losses is because encroached by you. This is causation. And remoteness, which is the losses cannot be too remote. Too remote means like too far. I can never know. Okay, how to determine whether it's remote or not? Number one, originally losses which arise naturally in the course of thing. For example, if you never come to my class, I will suffer loss is what? Tuition fee. So this is original. Every time will happen one, sure happen one. But extraordinary is like, for example, I tell you, hey, you guys, if don't attend my tuition, I will argue with my girlfriend. I will break down and I will langgar my car, something like that. That one is extraordinary, which is in usual situation, it won't happen. But because when I tell you already, within your contemplations, but you still choose to breach a contract, then you need to liable for it. I give you a scenario. In past question, if I remember correctly, there's one past question that they say, oh, I wanted to buy a land. I even tell the buyer already, the seller already. I say, hey, I need this land urgently because I got the 1 million order. So if you breach of the contract, I will suffer million. Okay. In usual situation, when you buy a land, you won't suffer million losses, okay? Because buy a land only, I sell you the land. Why I expecting to pay you the million profit land? But because in that case, I told you, and it's within your contemplation, you knew it. You knew when you breach a contract, I will suffer 1 million losses. Although it's extraordinary, although it may look remote, you still need to liable for it. I give you another scenario. Let's say I buy a flight ticket. I want to go to China. I want to go there and discuss the business. Then the flight delay. So it crossed me cannot go to China to discuss the business. In that case, in general, I cannot claim for the losses because it's too remote, too far. How can people know I taking flight to do what, right? But if let's say I expressly tell them this is so urgent for me, I told them already, you don't delay the flight. I need it urgently. Then within that contemplation, you may able to claim. You may able to claim. Because the court may take into account different factor lah. This is just two factor they will consider lah. And last one is like mitigation, which means you cannot just say, okay lah, you breach already, okay lah, I lie in the house, I claim you for million. Cannot. You must do something to reduce the losses. This is the duty lah. Okay. Okay, I saw a question. For contract, sometimes the question say, assume there is a cause of action and no defense. Discuss the final and interim remedy available to the plaintiff. Beside the usual termination, affirm, specific performance and injunction, what other remedy can we put, especially when the question had 25 marks? Okay, I think this is the latest question they asked. That's why I said usually they will ask cross action, but in the latest one, I noticed they don't straight away ask cross action anymore. They will ask you about interim, final. This is in the latest past question, if I'm not mistaken, they are asking about prohibitory injunction and specific performance. I think this is all you can ask really. Usually when they ask interim and final, right? My understanding is that they are asking for equitable remedy, as in what injunctions are specific performance. Why? Because you know, last time before we have equity, the common law remedy we have is damages only, which is whatever claim you against the other persons, in court you can only claim for damages, money only. But when you say you want what final remedy as in like the money is not enough for me, you need to claim is the equitable damages, equitable remedy, which is injunction, rescissions, specific performance. But I think the most common one in contract will be injunction and specific performance. Okay? And damages, as we just discussed, but do take note, damages for breach of contract is 74. And damages for voidable contract is 76. Okay? But they are using different tests. Okay, the differences is 76 only says a person rightly received the contract is entitled to compensation any damages which he has sustained through a non-fulfillment of contract, which means you can only claim damages, literal interpretations, you can only claim damages when you rescind the contract. Actually, for affirm, they are silent. They never mention for affirm you can claim damages. But on the other hand, for 74, regardless you are affirm or regardless you are terminate, you can still claim for damages. So this is the differences. But usually, if you ask me, right, let's say the classic question they ask they say developer promise to give you something, they use verbally in the contract, never say so, then when you want to sue, right, your cross action is either misrepresentation or breach of contract. Why? Misrepresentation because you tipu me, you say got this, but you never give me. And then breach of contract is like, you promise but never give, I want to terminate the contract. Okay. In that case, actually, you got two cross action, misrep and terminate. If you write fast, I will advise you to write two lah. But if you write slow, you just choose one. And I preferably ask you to write termination. Because termination, breach of contract is easier. The misread, I think you need to memorize all these requirement. I think is extra burden for you lah. Okay. But if you write fast, you can write two lah. Okay. So this is the charge. Then we go to the terms of contract. I think this part you can ignore lah. This part I think they rarely ask lah. You can straight away focus on this parol evidence. So what is parol evidence? So in general, we can say it's oral evidence lah. Okay, means in usual circumstances, we will just rely on the written contract. Let's say written contract say I sell you blue car. We will just look at the written contract. But in some situation, the agent or salesman may verbally promise you something. Those things are not stated in the contract. In order to admit those oral agreement, we call parol evidence. Okay. So section 91 say, in usual situation, we only see the written contract. We don't see oral contract. Then 92 is the exceptions. So the exception usually applied here will be 92B and 92C. B is like when the oral contract is not inconsistent with the main contract. What does it mean? For example, the written contract say, I will sell you blue car. But then you cannot say verbally, actually, I will sell you green car. So this is inconsistent. Then this kind of verbal contract, we cannot admit. You must be consistent one. For example, in written contract, we say, I sell you blue car. But in verbal, I say, I give you, let's say, some free gift. Okay, that one okay, because not inconsistent. Okay. Then 92C, condition precedent. Condition precedent is like, I have a condition. Because of that condition, only I enter this contract. For example, the salesman say, you buy. This car, I assure you, can, let's say the classic case, what is the Tanjong Motor. In this case, the Tanjong Motor tell the Australian guy to say, yeah, this car you can drive in Australia, comply with Australia rules already one. Okay, so because of this assurance, then this Australian guy go and bought this car. But however, cannot be used in Australia, so that's why they sue. But when they sue, then this Tanjong Motor say, no, this is not stated in the contract. But the court still rules the oral agreement is admissible. Why? Because the Australian guy bought this car is because of your assurance, which is your condition precedent. I buy this car because of your condition. You assure, only I buy. So in that case, because of you inducing me into the contract, I can rely on this oral agreement. Okay? Collateral means like exit side by side, which in written contract say you're selling me a car. Oral contract say I give you something else, or I give you extra discount. So all this is contract side by side. 92 is for statute exception. Collateral contract is a common law exceptions lah. But actually collateral quite similar to inconsistent lah, quite similar lah. Okay. Then exemption and exclusion. This question, if I remember correctly, the past year question only asked one time only, which is if you guys remember, there's a past year question asked about keeping things and then storing, and then some people just broke in and then steal the thing, and then the company say, hey, I got the exclusion clause to say I will not be held liable, if you guys remember lah. Okay, so exclusion means I want to exclude my liability. I don't have liable for that. Okay, in LLB they will ask you very details to say when did you tell the exclusion clause how you interpret. I just briefly mentioned these two but actually exam never ask until so detailed. Why notice is because in UK the law is that you want to have exclusion clause, okay, but the exclusion clause must give the notice before entering a contract. For example, I enter into a hotel. I wanted to stay in the hotel for one night. But the hotel never tell me the rules to say, if you make the room dirty, you need to pay 50 ringgit, for example. So they never tell when I enter contract, I pay the money already, I get into the room, only they got write this rule. Okay. Or they only say, if you fall down on this room, I will not help liable. They write something like that, which means the notice came after I enter the contract, I pay the money. This kind of exclusion cannot be accepted. So notice means since when you give the notice. the good practice is you must tell them the exclusion clause before they enter a contract. Otherwise, the exclusion cannot be applied. Interpretation means how you interpret the exclusion clause. So, for example, in all contract, they will always say, I will not be held liable for your losses. If the clause is too wide and unclear, the contra preferential rules means they will interpret the rules in favor of the customer. So when you say, oh, I will not have liable, but never specify what liable, then the court will help me to say, hey, it's unclear, never mind, I will not apply this rule, something like that. So what we'll ask in the past question is, I think you need to remember this case, CMB versus Anthony Lawrence. In this case, the Anthony Lawrence, they take a loan from CMB Bank. But CMB Bank standard clause, they will mention if the bank fail to release money to the developer, we will not be held liable. Okay. Then federal court says that, hey, you as a bank, your duty is to release money. Then how can you tell people you cannot be held liable for that? So Section 29 Contracts Act apply. Because in this case, Section 29 says, you cannot restrict of legal proceeding. You cannot say people cannot sue you. So similarly, if those people say, okay, you come to my facial, do guilty, if anything negligent, you cannot sue me. You sign already, this kind of clause is a void contract. So this case, I think, if I'm not mistaken, only asked one time before. Okay? So this is the first thing. Then, deposit, I think never asked before. We can focus on this LAD. So LAD, it means, you see, like just now the damages we say, if you wanted to claim damages, you need to prove causation and remoteness. But LAD is the shortcut to it. Why? So let's say today, if you guys never come to my tuition, I need to prove causation. You cross me what suffer losses. I need to prove what are the damages, whether not remote or not. So troublesome. But you can actually straight away put in the cross in the agreement to say, whoever don't come to my class, I can sue you for 100,000. This is LAD. You see, liquidated as certain damages. We straight away write down already what are the damages. This is LAD. But I think what you need to remember is this later case, QB case. So last time, the what are the party? The defaulting party, the innocent party need to prove, there is no longer a strict requirement to prove all of the losses suffered by the innocent party. The defaulting party need to prove the LAD clause is unreasonable. What does it mean? It means last time, if you are the innocent party, let's say I sign contract with you, then you breach your contract. I, as an innocent party, I need to prove the LAD is reasonable, the amount is reasonable. Because the party who breaching the contract will say, you where got suffer so loss, you need to prove unreasonable, I never earn so much. Okay. But now the burden shift already. The defaulting party, which is the person who breach of the contract, need to prove the LAD is unreasonable. Otherwise, then they need to pay the money already. I give you a scenario. I have a case, it's a property agency. So the company make a contract to ask the agent to stay in the company at least 2 years. So the company say, if you resign within 2 years, you need to pay me 300,000. So the agent resign, then the company sue them for 300,000 LAD cross. Then in this case, my client, if my client breach of the contract, need to prove the 300,000 is unreasonable. But last time it's not like that. After QB case, it's like this already. Understand? Okay. Then I think that is. Oh, I saw a case. They say the question LAD is the case of Matt Villa relevant. Can you give me the full name? Is there a latest case? Matt Villa. Okay, put aside first. So this is for our contract. Okay. Then we go to our tort. So for tort, like I mentioned just now, for part A, they will ask about the cross of action. So the cross of action here, you need to mention duty of care, breach of duty, and causations. Okay. So I know many people will confuse when they especially they will ask me, hey, Mr. Renault, if it's an accident case, if it's a nuisance, if it's an occupier liability, how do I discuss? Actually, you will notice regardless what type of causations regardless of accident, regardless of occupier, regardless of nuisance, all of them sure got duty of care, breach of duty, and causation. how to say, like accident. So then you say, "Lor, you are road user, use the road. How can you not own the duty of care to me? Let's say occupier, you come to my house, regardless you are trespasser, regardless you are visitor, regardless you are who you are, you come to my house, I must take care of you, I cannot create a danger to you, And nuisance also. As long as I disturb someone, my neighbor, if it's a private nuisance, then the duty, okay, I own to my neighbor. If it's a public nuisance, then I own to the public. Then statutory duty is like depends on the local government. Let's say you stay in KL, then it's DPKL, right? So all of them sure got the duty of care. Then whenever they don't do the duty, it's a breach of duty already, then remove causation. Causation all is the same lah. But for your negligence, I wouldn't suffer losses. Okay. Okay, I saw the case. I don't know this case, but is it a later case? I can jot down first, later I check and then I update in the group. Last time I think some student they asked about the question, I answer her already. Okay. So this is the element for negligence. Then defense, usually they will ask contributing negligence and warrant type feet injury. Okay, so the difference between contributing negligence, I think you can understand like contributing means like 50%. You got wrong, I also got wrong. Warrant type is like totally you're wrong. It's your fault. You speed too fast. That's why we langgar. Okay, so this is the differences. Okay, I saw a question. Let's say there's a vicarious liability. Is negligence also applicable against the employee or just discuss vicarious liability and enough? Okay, vicarious liability actually means when the employee do something wrong, the employee, whatever he do in the course of employment, the boss will help liable. So I think negligence, yes, apply to both employer and employee. So when you write the statement of claim, you actually suing both. But why you want to sue the boss is because the boss is richer, the employee where got money to pay you. So vicarious liability actually is in the way to pull the boss to be liable together. Okay. Then damages. Okay, I think damages is many people they don't understand and they get confused. Okay, I saw another question. For causation, do we need to choose between but-for test or material contribution test? Okay, for me, I only choose the causation, the but-for test only. I know, I forgot is LLP or CLP. One is we will discuss causation in law and causation in facts. But for me, I just discuss causation. I straight away discuss but-for test only. Okay. Okay. For damages, let me explain. We will straight away divide into personal injury and fatal injury first. Okay. I think no longer we should call accident because last time it's only accident but now more than accident already. They ask you nuisance or something. Okay. When you are just personal injured only, you can divide into special damages and general damages. So what is special? What is general? Special means like those you are able to prove you got receipt. For example, hospital bill. For example, your car repair. Okay. But general damages is something decided by the court. Yes, there's a calculation for loss of future earning, but it still depends on the court to give you. In other words, special damages is proved by yourself. General damages is ascertained by the court. Okay. So the example will be medical bill, cost of care, which means you tell the court, hey, I now need kakak to hire to take care of me. So that's why their calculation is either, let's say your mother give out the job to take care of you, the loss of income, or the market value of the kakak. Okay. Sorry, it's not discriminating or what. I'm just using the word kakak. Then general damages. General damages is loss of future earning or loss of earning capacity. These two earning future earning is like when you are receiving earning, then now you cannot earn already, you tell the court, please, I cannot work, I'm suffering, please help me. Okay. Loss of earning capacity is like when the accident happened, you are not working, because one of the requirements for future earning, you must receiving earning. But if you are the student or you are retirement, doesn't mean you cannot claim. You still need money to survive. Then you claim loss of earning capacity. Okay. Then pain and suffering, loss of amenity. All this is under general damages. And remember, rules of court says that general damages can never be quantified because it's up to the court to decide. It's not up to you to decide. So that's why when you write statement of claim, you just say, I want general damages. Okay. Then come to fatal injury, which means somebody die. When somebody die, then you have two, dependency or estate. So what are the difference between these two? Dependency means like I'm the wife, I'm the kid, I'm the parents. I'm relying on the deceased to survive. For example, my son, okay? Because now they pass away already, nobody can rely. I'm suffering loss, so I claim for dependency. Estate, on the other hand, is like you claiming on behalf of the estate. So what are the difference? What are the main thing for you to decide to claim estate claim is, let's say they are telling you the deceased before he died is suffering. So you want to claim for pain and suffering, then you ask for estate claim. So let's say the facts is saying, oh, after accident, the deceased suffering 5 days only die. In that case, you want to claim for pain and suffering for this disease, then you need to remember to say, I want to claim for estate claim. Because dependency is not claiming for the disease, so you cannot claim for dependency claim. Okay. Okay, so the questions are for cost of care, the calculation for the multiplier amounts to 4 options available. Mara, Baden, Bucha, some case, and the question does not specify how it should be calculated. Do we discuss all 4, or can we just choose one without mentioning the other 3? Okay, good question. I think you asked this is because BAC, they mentioned all 4. That's why I say, you see, although there's a calculation there, actually this method applies to future earning also. The multiplier, actually, they got like different calculation. But for me, I will just straight away choose and follow this one, which is below 30 years old, 16 years, above 31 years old, your age 16 minus your age divided by 2. I won't mention about other button, whatever case, because those, like they will say, take into account you are not traveling lah, you are not working lah, etc. I will just choose this one only. I wouldn't discuss that much because you don't have time, and also those is more like for the court to decide and not for you to decide. Okay, someone may wondering, hey, right now just now you say cost of care should be special damages, how come future care also here? Okay, please take note, the cost of care can be divided into pre-trial and post-trial. Pre-trial means that before you fight in the court, so we claim the cost of care, whatever I spent already, I got the receipt one. But in the future, I also wanted to claim. So that one is future care. So that one is what the student is asking, the matter how to what. I think that one you don't need to emphasize so much. You just need to say, oh, we wanted to claim for cost of care because the medical report say I need the future care. That's it. You don't need to mention all these matter. And this matter you mentioned actually applicable to future earning also. I will just mention quickly. I just say according to multiplier, according to this section, the calculation is like this. That's it. I never mentioned all 4 types. Okay. Another question, in SOC, do we plead for dependency and estate claim? Okay. You can actually claim for both estate and dependency. You can claim for both. But when you write the SOC, you need to be very careful. Later, I will mention. Okay. But if let's say you choose dependency already, then you remember you are claiming for yourself or your son or your parents. Okay. Loss of support. As in like, I need this disease to support my life. Okay. So when I support my life, same, when you calculate the multiplier, I will just use this. Because I know in BSc book, they will tell you, hey, the disease no longer eating the disease no longer traveling why you want to claim so much? But remember, I think you can straight away just say the actual benefit I deprived to. For example, the facts will always tell you, oh, my husband earned 5,000, he give me 3,000, paying the car loan 100, and then paying the children 500, something like that. Actually, all these facts you can ignore. You just mention 3,000. Why? Because actual benefit deprived of, which is the husband give you how much, then you just claim that much only. I will use that lah. But again, if you guys wanted to impress the examiner, you can write longer. But for me, I will use this case to say actual benefit. Okay. So this is for dependency. Remember, I'm depending on the deceased to survive. So the person can be the wife, the kid, the parents. But estate actually claiming the almost the same thing. Why? Medical for the deceased because of the deceased die, I need to apply LA okay, and funeral And most important is, if there is no pain and suffering, I don't think you need to claim estate claim. Usually we will make estate claim is where we want to claim pain and suffering. Otherwise, funeral, he already got one, right? But all this is extra up to you whether you want to claim. But for my observation, past question never asked about grant, cost of extracting grant. Medical bill, unless the question especially mentioned the deceased got medical bill. Otherwise, you don't need to claim for estate claim also. Okay, so to answer your question, you say, can we plead for dependency and estate? The answer is yes. You can mix 2 together to say, I am claiming, I just quickly show you. So for estate, you see, we are saying we are executor and executrix. Depends on whether got probate or LA . And for dependency, we say we suing on behalf as a dependence. So when both you mix together, you only write this. Because this title is given by court. But this one, you just write in general only, just say, hey, who am I only, okay? And right here, when the first paragraph, then you remember, because if you write estate, you need to say, oh, for the benefit of estate under Section 8. But for dependency, you need to say, oh, under Section 7. But when you mix both together, you need to write both. You need to say, I am the executor of the deceased, where the property has the extra on when, under Section 8. And I also, as the so-and-so deceased, and I bring under Section 7. So you need to mix both together. But mention when this capacity, you just need to mention executor only. Understand? Then, okay, this is all damages lah. And this timeline, I don't think they will ask you any more lah. Why? Because in 2019, there's an amendment. So when there's an amendment, they will follow the old law. But after this 1st of September 2019, now also 6 years already, I don't think they will ask that. Because it's only the accident happened after this year, they will follow the new law. Okay? Then damages further, I think we can take note is these deductions. So please take note, the spirit of silver claim is you must suffer loss only you can claim. But the sections here mentioned quite nice, because it mentions the following item is irrelevant in assessing damages. Means when you are making a claim, the court cannot say, hey, you pay by insurance already, hey, your pension pay already, hey, any other stock pay you already. So you cannot claim, cannot. Because this one, when the court accept damages, the court cannot say, since you covered by insurance already, I don't want to make this claim for you. Cannot, because I got insurance is I private contract with the insurance company. It doesn't matter, it doesn't affect the claim against the defendant. So understand, which means I'm making a claim against the defendant. The court shouldn't take into account whether my claim is paid by compensation by the insurance company or SOXO or whatsoever. Cannot. Okay. But we do have cases they make a differences So in this static warrant cases, the court says since your medical expenses is covered by the insurance already, therefore the court didn't give you the right to claim for medical expenses. This is what static warrant say. But in court appeal case, Song Cheng Ling, this court still allow medical claim. They say apply Section 28, capital A. It doesn't matter whether the plaintiff got bought by insurance or not. Okay, I asked see the question, will you sharing the document? Sorry, I'm not. Okay, so this is for the deductions. Okay. Okay, another question. If the question involves vicarious liability, should we claim damages separately from both employer and tortfeasor in SOC? I don't think so. Because you see, when you write SOC, you will write like first defendant and second defendant. First defendant, up to you. You want to prove employee first also can, employer first also can. But at the end, you wanted to ask them joint and severable liable. Joint means like join together. Severable means like separate also can. So which means either one liable also can. So which means you don't need to say, oh, the boss pay me 500 and the employee pay me 400. No, you just say joint and severable liable. Okay. Then, oh, I think my electricity stopped. The other electricity. Wait, yeah, just a moment. My house. Okay, can you guys see the screen? Oh, I think I stopped sharing already. Let me share. Okay. Sorry, my internet got problems just now. Okay, so can you guys see the screen I'm sharing? So we continue about the statement of claim. So for statement of claim, I personally think it's slightly harder than contract, because for contract statement of claim, it's just party. You just need to write who is the party, then the formation of contract, or whether there's a contract, then there's a breach of contract, then what kind of remedy you want. Simple as that. But for tort, why I think it's slightly harder is because number one, you need to write the capacity. Because in this case, they are not that straightforward, just mention who are you, because you may be represented by someone else, or you may represent someone for someone else. Okay. And the introduction also is not that simple, just write you are individual having a postal address. It's more like you need to write who are you, why you are bringing these actions. Okay, this is a different one. So you see, normal personal injury, just write who are you. But for dependency, you need to write you bring the action under Section 7. And then for estate claim, you will say you are the executor or administrator under Section 8. Okay. Then defendant will be the same lah. Okay. Then the accident happened also is the same. Okay. Then the car plate number and the collision also is the same. Okay. Negligence also will be the same, as you can see in the police report to say speed limit or fail to control and manage the motor car okay, all is the same. Then here will be slightly different already. For personal injury, you need to mention what kind of personal injury you have. But for dependency, you will need to mention how many days you die, and particular pursuant to Section 7. This one is only for dependency only. Why? Imagine, you see, when you write the Part A, you need to write who are you, how old are you, how much you earn, all that, right? All this also you need to mention in your statement of claim. On the other hand, for the estate claim, you need to write is the particular of the deceased injury. I think you can understand that because you need to write whether there is a pain and suffering or not. So how many days he died later and how he suffered, all that also you need to mention. Then only the court can check whether we can claim for pain and suffering. Okay. Then personal injury, then after you list out the personal injury already, then you write what is the special damages you want. For dependency also the same. What are the special damages you want? And then for estate claim also, what are the special damages you want? Then the relief all is the same already. So you see, actually, there only 2 or 3 parts is not the same. So number 1, the title, okay. Number 2, the introductions, okay. And number 3, the particular. For personal injury, is particular injury. For dependency, is particular pursuant to Section 7. For estate claim, is particular for deceased injury. So this is the slightly different from each of the cross of action mentioned in this personal injury, dependency claim, and estate claim. Okay. So you guys have any questions? I think I saw a question this just now I asked the question about vicarious liability in statement of claim. But if it involves non-delegated claim against an independent contractor and negligent claim against the tortfeasor, then should we claim damages separately from both of them separately? I am not sure why you mentioned non-delegable claim. But what I can recall is based on the past year questions, the situation is like this. Correct me if I'm not answering your questions. A management hire a contractor come to fix the lift or some electrical things like. Then there's an explosion happen, so the technician get injured. So the question now is, this technician should sue the management because of occupier liability or should sue their own boss? Okay, I think in that question my answer is that, and there's a case law also, you should sue the independent contractor. Why? Because you are the person who know how to do your job. You are the expert on this area. Then you shouldn't sue the management because management hired you. You are the independent contractor. You are not work for the management, but you work for your boss. Your boss should take care of you, not the management should take care of you. There's a case law one. So I mean, I don't get it why you say non-delegable. Maybe when you say non-delegable means like this job is your job. You shouldn't assign to other people, so non-delegated. But please correct me if I'm not answering your questions. Let me see. I think it's this one. Yeah, I think it's this one. Okay, so for this case, yeah, the respondent defendant operating a shopping center. He engaged a contractor Govin to undertake certain electrical work at its premise. Govin was not, however, appropriately qualified to undertake the work. He then correctly engaged a qualified electrician, Anand Malai, to undertake certain cable joining work. The plaintiff, the appellant before this court, was the employee of Anand Malai. So which means shopping mall hire Govin. Govin hire Anand Malai. Anand Malai punya employee is a person injured in this case. So this is the relationship lah. So if I remember correctly, at the end the court said you shouldn't sue for the shopping mall. Okay, the plaintiff in the present case was not an employee of the independent contractor engaged by the respondent, which is Govin, because management hire Govin. So this plaintiff is not worth undergoing, So, okay, he was in fact an employee of the independent subcontractor engaged by the defendant, independent contractor, which is Alam Alai. Okay. There was no unusual danger present in the premise. The defendant engaged an electrical technician to undertake the job precisely because the job required a duly qualified technician. When someone is engaged to undertake a job that requires certification to undertake, one can reasonably expect that the duly certified and qualified person will be best placed to assess the risk that may potentially arise from the work to be undertaken, the relationship between the party that of an occupier of the premise and the employee of an independent subcontractor with whom the occupier had no contractual nexus was not sufficiently proximate as to give rise to a duty of care. It would not be fair and just and reasonable to impose a duty of care because the defendant had done all reasonably prudent person could have done in the circumstances, which was to engage an electrician. So in that case, I mean, I hope I understand your questions. There is a difference between independent contractor and also the person who hire you. And I think this case may change if the management straight away hire Alam Malai and Alam Malai assign the work to the employee. Maybe it will change. Because in this case, they say the management don't even know you. There's no contract between the management with you. The management hire going, hire your boss. So you should go and sue your boss and the contractor. Is not sue us. So this is what's stated in this case. But this case, I think slightly complicated is because that time in the independent contractor is not that famous. I think one thing I can highlight to you guys is this noctus actus intervening. What does it mean? You see, just now we say one of the element for tort is that it must be a causation. You cross me, suffer losses. Okay, but what does it mean of novus actus intervening means the change of causation has been breached. For example, I hit your car, so you suffer, injured. But when the ambulance send you to the hospital, someone langgar your car again, hit your car again. So you suffer more loss, more pain or what. So then, if the injured gets serious, I, as the defendant, I will argue, your causation is not merely crossed by me. I hit you, that time you still okay one. But the second person hit you, then only cross you, suffer more loss. Then you should sue for the second person for more compensation. Maybe I will like allocate maybe 30%. The 70% you should sue for the second defendant. Something like that. So in this case, the independent contractor is because it's so far away from the shopping mall. It is not under my control. I hire going hire you, then you should ask going why never provide you the safety, or ask your boss why never provide you the service. I don't even know you. So this is the differences. Okay. So this is the briefly go through of the general paper. Do you guys have any questions you want to ask me? I think just now I said I wanted to show you the question, right? The formation. Okay, I think I can quickly just show you. Let me see. Formation of contract 2019 supplementary. So this one I think is a typical question they wanted to test you for offer acceptance. Why? Because you see, this question is very long, but I just quickly go through it. Basically, they say this ADA company wanted to buy a land. So they find the seller. Oh, sorry. ADA property is a seller. So Googling Senior Berhad is the buyer. So then they enter into this subject to contract. They say, oh, okay, how much is the purchase price? When do you need to pay me? And also all the details are. But again, this is the key word about subject to contract. As in like we are still writing, but we never confirm, we never sign a proper contract. So when they mention this like letter, send you over how much negotiating the price actually is a hint for to tell you that they want you to discuss about the formation of contract. I show you another more questions. Just okay. So this is another one also long. the government says they wanted to offer you, sorry, there's a tender, and then you trying to tender the contract, and then you ask somebody to check whether they can help you or not, they undertake, etc. All this also they wanted you to discuss the offer acceptance, okay, and also consideration. Why? Because when you pay, then the party need to, and you can have the right to enforce the contract as well, ma. Let me show you more. I wanted to show you more. Okay, this is the one just now I say for the exclusion clause. Yeah, because hilang barang, they say they help you to store the thing, your things. If like burglary happen, I would not be held liable for that. Remember the CMB versus Anthony Lawrence. Okay, let me see if I have more. 22. This one also is not. Wait, let me show you more. This one. So let me repeat. So for this question, you see when they mention all the date, whether there's an offer, whether there's acceptance, and then we still negotiating, and this is another one. Now I write invitation to tender, then see who can get the offer, and then I counter offer, something like that. So let me further explain also what is the difference between ITT and offer. So offer is like I expressly tell you, do you want to attend my class? Do you want to buy my notes? I offer to you. Once you accept, then I must give you. Okay. ITT on the other hand, there is no specific person. I make the offer to the whole world. This is ITT. When people say, hey, I wanted to buy, hey, I wanted to join, I can still choose yes or no. So in that case, I'm acceptance, which means I make ITT to the whole world. People come forward and make me an offer. Then I can decide whether I want to accept or not. This is the difference between ITT and offer. Let me repeat. Offer is there is a specific person I make to. ITT is I make to the whole world. Okay, and I can still choose whether I want to accept your offer or not. So ITT is this one ITT lah, invitation to tender or invitation to treat. Okay, so this is the thing I want to share. So do you have any question you want to check with me? Okay, I saw a question. Can you please explain the principle laid down in American Sanomine on the ground of a prohibitory injunction and when such principle should be applied? Okay, American Sanomine is for the prohibitory injunction, as you guys know, law. As in like when you wanted to apply for the injunction, right? Different type of injunction, they have different type of the what we call requirement need to satisfy. Okay, so the principle here, if I remember, follow ATC lah. Last time I follow one of the ATC teacher punya. The requirement here is like this: serious question to be trial, compensation insufficient, undertaking as to damages, balance of hardship, full and frank disclosure, and prompt application. Okay, so your question is when such principle should apply. My time, now I think it's different. My time actually they will ask the differences between the summary all type of injunction. They may randomly ask you whichever. Then you need to memorize so much. So I choose to skip my year. But I noticed the reason year they ask, they were more like asking you about the procedure. As in like, hey, now I wanted to apply ex parte. Is it okay? What is the procedure? How many days? Something like that. But to answer your question, you say the requirements are, I think I can give you the key point to remember is that, you see, injunction is an equitable remedy. So which means, like I said, last time when we only have common law, our only remedy is damages. So in order for you to get the equity, you need to justify why you need to get such a powerful thing, the equity. So you must show that. You see, prohibitory means like I want to prohibit you to do something. You must show the cause that something so serious. I wanted to hold this thing. I wanted to stop something so that my right would not be affected. Or when I win the case, the judgment wouldn't become redundant. Lebe. And compensation is insufficient. These compensation insufficiencies actually apply to most of the equitable remedy. if you study the specific release act, I think one of the section do mentions that if money can settle your losses, you should just go for money. You shouldn't go for this what we call injunction or specific performance. Okay. Then undertaking as to damages, you will notice now you see all also got undertaking as to damages one. So what is this undertaking as to damages? Undertaking means like I promise something, just like what you learn in professional practice. As to damages means like you see, like I say, injunction is a very powerful thing. For example, I say you cannot go to your company every day. So in that case, then you need to undertake when you want to get such a powerful thing. Let's say, or you say you want to freeze my account. You need to ensure it's because of your injunction I suffer losses. For example, I have a case discussed with my client, million, or my client will go to jail if I don't go to court. But because of your injunction, my client suffer loss, he come back and sue me, then I can sue you. This is the undertaking as to damages. And then balance of hardship actually is the same as serial question. As like I really need this kind of injunction. Otherwise, it's unfair to my situation. Full and frank disclosure means like you need to tell the court the full facts. And then prompt application, you will notice also got prompt application. Which means you need to make fast law. To memorize all this, I think my skill I don't encourage you to memorize all Actually, you just need to write a few things which will come out very often one. For example, undertaking sure got one, prompt application sure got one, serial question sure got one. Why? You see, serial question and arguable case and prima facie case easily is the same thing. So I think you can just take the rough idea and just write. And you don't need to write like one by one, like 1, 2, 3, 4, 5, 6, and then discuss each of the requirement. Because you will notice the question wouldn't give you the full facts until you can discuss all one. For my style, I will usually just say, okay, following the case of American Sodomite, the requirement are A, B, C, D, E. So for the facts, it seems like there is a serial question because blah, 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 blah. Just like that. You don't need to discuss one by one. Okay. So your next question is, additionally, could you explain the third Chandri's shipping in relation to Mareva injunction? Mareva injunction. So it's this case. Then, okay, again, it's the same. The requirement is here, good arguable case actually isn't it a serial question to be tried. Amounts of claim. Why? Because you see, you want to freeze people punya account, then you must tell takkan you actually just 150 ringgit, you freeze people million ringgit account. Full and frank disclosure, you see, here also got And then access within jurisdiction, I think also fair Takkan you ask the Malaysia court to freeze Singapore account Risk the defendant is disposing asset, I think also free I mean fair You must ensure they will dispose If people living nice house and still in Malaysia doing business, how can you say there's a risk they will dispose And then the last two is the same undertaking and prompt application Am I answer you correctly? You are asking how to memorize it. Okay, sir, wanted to ask for thought. Calculation of the multiplicand for loss of future earning. There's method whereby you take income minus tax plus EPF minus living expenses. Since the question doesn't give you the EPF and tax, can you show the calculation like this? Okay, this one actually is the same like the multiplier. Just I think is you ask, right? I usually just straight away take the amount of salary and also the how much amount of salary for personal injury and also take how much the disease used to give you your actual benefit for the what we call let me mute first for the dependency claim. You see, I understand why you guys will ask about all these different method and also tax EPF is because BAC book says so. But you will notice actually in exam they will never give you this facts one to say how much is my EPF or that. Never. So they never tell you all these facts. So to answer CLP question, you just need to tell based on the facts, which is how much they give you for the what we call the salary. I give you I simply show you one. For example, these past year questions we wanted to claim. So they say at the time of the accident, I was paid 30,000 bangli. I gave Wani 80,000 for house expenses to pay all the loan. And her expenses, I did not want her to work. I spent 5,000 on my own needs. So you see, based on these informations, if they are claiming for personal injury, I will use 30,000. You don't need to mention all these like EPF, etc. Why? Because number one, the facts never give you. Number two, you of course help the client to claim the higher amount. It should be the other party to oppose to say, hey, you will earn so much, we got 30,000. This is gross or this is net. Okay. Number two, if you are claiming for dependency, Then we use 18,000, the actual benefit deprived from the deceased. Okay, so this is the information usually I will straight away use. You don't need to mention all this EPF, all that lah. But in practice, maybe yes, you need to mention that details lah. Okay. Okay, next question, sir. Referring to the earlier questions, may I also ask about the deduction of living expenses in both fatal injury and personal injury claim? Should the deduction cover only expenses incurred in earning the income, or does it include the general living expenses of the deceased plaintiff as well? Thank you. Okay, this one is the same. Like I say, you are not supposed to deduct, number one, all the insurance, all the money paid by your boss or EPS also. This is number one. Number two, I know from the textbook they will tell you, for example, we say dependency claim. I earn 5,000. I give my wife 3,000. I use 2,000 for my own. Today I die. My wife want to claim for dependency. Yes, according to case law, they will say, hey, Renault now die already, ma. You don't need to cook for Renault already. Why you need 3,000? You only need 2,000 for yourself. Okay, yes, case law, even they dispute like that. But in passive question, you will notice they never give you the facts like that. Actually, you can just straight away tell, my husband used to give me 3,000, therefore my multiplicand is 3,000, like the question I showed you just now. So actually, you don't even need to mention the living expenses all that unless the facts tell you. But for my observation, I think the facts never says that. Okay. I see one question in the private chat box. Can you show us the statement of claim on contract, how it look like? Okay. I quickly show you how the statement of claim look like. Okay. For statement of claim, like I say, it's pretty straightforward. Number one, we write which court, plaintiff, defendant. This is the same lah. For all kind of statement of claim is the same. Party, right long, where they stay, who are them, company, individual, defendant also the same. Then you write the formation of contract. As like when and when we wanted to take this project, I approach, assure that he can secure the project. So in view of that, we enter into a contract, and then we do what? Okay, formation of contract. Then only you say, okay, there's a breach of contract. Why? Because of the what happened. So it made me suffer losses. Okay, since you fail to perform, I want you to refund to me. Then remedy. As simple as that. Okay, I can show you one more. Okay, same. Intitulment. This one we call intitulment. Then after that, who is the party? What is the formation of contract? Like there's a purchase order, there's a delivery order. Okay, then there's a breach of contract when you say they didn't fulfill the contract. Why always there's a formation and breach of contract is because you see, when you come to court, the judge is a third party. The judge don't know the full story, ma. So you might at least tell why you think there's a contract. Otherwise, then why this is a contract subject, right? So you must tell. Then only relief. Okay. So this is additional point for the frustration. This one, if you want to mention, if you don't want to mention, also can. Okay, another question, sir. How do we identify or differentiate whether to discuss vicarious liability or occupier? Like past question 2022 discusses now, occupier can be relevant too, right? As the shopping complex is premise and they own DOC, duty of care. Okay. In order to impress the examiner, for the similar question, I will still ask you guys to discuss what we call the both party, which is the occupier and also the independent contractor. Why? Because if you straight away say, oh, there's no duty of care, then isn't it you never explain to the what we call the examiner that actually you understand the question, but then your own analysis tells you that they cannot be sue liable. Okay, I give you a scenario. So in this case, shopping mall called Alibaba. Alibaba call Paka, K Paka Enterprise. K Paka Enterprise call his employee. Okay, so it's like 4 level. Shopping mall, Alibaba, Paka Enterprise, the plaintiff. Okay. Why we still need to discuss both is because, you see, when the first question asks you what is the cause of action, you cannot straight away jump into to say, we must sue the boss only. We cannot sue the complex, ma. Cannot, ma. You must analyze one by one, then tell the examiner why you think we shouldn't sue. So I roughly show you lah how I read. Oh, I don't have sample answer. But never mind, I simply show you one. I show you one. See if I have. Yeah, too many already. I off some. Occupier, let me see. Occupier 2022. Yeah, but I don't have 2022. Okay, but never mind. I just quickly show you how I write. Okay, so if I were you to answer that questions, the shopping mall complex, I would say, in order to sue uh, the defendant for negligence, we need to prove there are three elements, i.e., duty of care, breach of duty, and causations. To determine whether someone owes you a duty of care or not, we will need to look at the test of Parol industrial. Number one, whether the damages is foreseeable. Number two, whether there's a possibility of relationship. Number three, whether the imposition of duty is fair, just, and reasonable. Okay, law, introduction and law. Now facts. On the facts, the shopping mall hire Alibaba. Alibaba hire Paka Enterprise. Okay, so in order to determine whether we can sue these three persons or not, we need to determine whether they owe me a duty of care. So now we discuss the first shopping mall first. Whether the damages is foreseeable, whether it's proximity of relationship, whether it's fair, just, and reasonable. Okay. On the facts, the shopping mall never directly hire me or hire my boss because the boss shopping mall actually hire Alibaba first. So in that case, there is no proximity or relationship. And there is unfair to impose a fair judge and reasonable. Why? Because they don't even know my existence. So I will discuss that, then dismiss. Then only you discuss Alibaba. I think Alibaba is foreseeable and proximity of relationship. Why? Because Alibaba hire your boss, ma. So two of them should have like some safety measurement to protect the employee, ma. But they want to leave it to you, lah. I think it's fair to impose on him, lah. Definitely you can sue your boss, but whether you can sue Alibaba or not. So you should answer like that. Okay? Can you understand? Yep. Okay, understand. Good. Anything else? Let me see. So if you guys don't have, we will stop here, or let us wait for 1 or 2 minutes. Maybe some of you are typing. Yeah, okay, I saw somebody asking. Okay. Meanwhile, I think if I'm not mistaken, the first paper is general paper, right? Your first paper. Yeah. And then silver. And then criminal. Yeah. How would you allocate time for each question and sections? Um, I think there's a calculation one, right? I forgot how long is the one paper already. Let me see. But if I remember correctly, 15 minutes is for 15 minutes is for the statement of claim. If I remember correctly. Let me see. I forgot already. So total answering time is 3 hours. If 3 hours, then means one question is 1 hour and a half. So 1 hour and a half, if I remember correctly, I think I forgot it's 15 minutes or 30 minutes for statement of claim. And then the rest of the time is for part A and part B. Yeah. But I forgot the time exactly time already lah. But unless you write the statement of claim very fast lah. But I always will tell the student, actually, right, if you answer your part A and part B nicely, part C shouldn't be a problem for you. You should be able to write quite fast one because your answer will be based on part A and part B. But if I remember correctly, it's 15 to 30 minutes for Part C, if I remember correctly. Okay, next question, sir. If we use Parol test, means no need to mention about the Donovan neighborhood principle, right? Okay. Good question. You see, the first negligence we have, actually we start from, if I'm not mistaken, it start from Donovan and Stevenson first. Donovan and Stevenson, the neighborhood principle, there's a nail in the ginger beer or something, then only they slowly change to this latest test is Parol test, So Parol test actually is the later test for Donovan and Stevenson. So you don't need to mention Donovan and Stevenson already. Okay, let me wait for our friend A. Are you still typing A? Or do you want to just straight away ask? I mean, open your voice to ask. Yes, still
So
typing.
I'm sorry, this is gonna be a bit noisy because I'm outside. That's why I don't want to open mic. But can you hear me?
Yeah, I can hear you.
Okay, so I wanted to ask, because for let's say like for contract, right, there is in question the first question we answered that there is for example there's a breach of misrepresentation and then there's a breach by way of section 40. So in our statement of claim, let's say we run out of time or anything. Can I just mention misrep only, or can I just mention the section 40 breach only and just not claim the other one, basically?
Can, actually can. Like I mentioned earlier just now, if you have two what we call clause of actions then like the example I give you, the developer promise to sell you a property in S&P, they only mention sell you the house, but their salesman like verbally promise to give you the CCTV, security feature, etc. But turns out there is none. Okay, there's none. So in that case, you can sue for misrepresentation to say, hey, you tipu me, it induced me to enter this contract. This is number one. Number two, you say there's a breach of contract, right? Okay, but then some student will ask me, hey, no Reno, there is no written contract those like CCTV feature is a verbal Okay, one you can say is a misrep that induce you into contract. Okay, number two, you need to mention about Parol evidence first, as in like you say, yes, the CCTV is an oral contract. It's never part of the contract, yes, but it's because condition precedent. I buy this house because of your promises. I enter this contract. So an oral contract will become the terms of the contract. So when you fail to do so, I can sue you for that. Same for this Tanjong Motor versus Alan McKnight. Understand? So you can straight away just say the breach of contract only. You don't need to write both. Okay, next question. If we write both misread and breach conclusion, we need to choose which one on prefer. Yeah, that's what I see. That's what I say. If you write both, at the end you still need to choose. Tell your client which clause the action to choose, You cannot write both, So preferably, if you want to save time and make it easier, you just straight away write breach of contract, Breach of contract is easier, right? If you write both, then at the end you still need to tell the court which one is better. And some more misread and breach, their remedy actually is slightly different. One is rescission, one is breach of contract, terminations. So one is like go back to the original position. One is like I don't want this contract at all. Please compensate me. Okay. So if fraudulent act occurred after entering into contract, how should we discuss? Fraudulent act, which mean, let's say I enter contract with you to sell you CLP notes, for example. Then actually, or I go and steal people punya notes, is it? Can you give me a scenario? Because right, the fraudulent conduct, it doesn't affect when the time you make contract, actually doesn't matter one. How to say, I mean, I don't know how exactly the question you want to ask, but my understanding is that when I enter contract with you, let's say I wanted to sell you something, the conduct, the fraudulent conduct or whatever conduct should be at the time when we enter contract. Later on, I do what? Let's say later on, I commit some offense. It doesn't matter because that one happen later. It should be at that time. Before that also, it depends whether it will affect the contract when you enter contract, the intention or not. For example, I say I got some, let's say I want to sell you this bottle. And when I sell you this bottle is mine, I can sell you, no problem. But if later on when I sell you already, let's say I want to sell you, I say, okay, on Monday, we exchange. But suddenly on Saturday, I hilang. I go and steal somebody punya bottle. That conduct itself is illegal. But the subject matter is still valid because I wanted to sell you this bottle. Bottle is valid one, ma. Unless on Monday I couldn't give you the bottle, then yes, there's a breach of contract lah. But it doesn't affect the validity of the contract, understand? You cannot say just because I lost the bottle, then the contract is void, ma. The contract is still valid, but just that I breach of contract, I couldn't give you, ma. Okay?
So another question. So
Yep.
for one of the past year questions, I forgot which specifically, but basically the content of it is there's a badminton and futsal court contract that they entered into. And then suddenly the badminton, there's a contract for the construction of badminton and basketball court. And then suddenly it's like added into the futsal court or whatever. But my question is this, it's like sorry. So my question is this, because later on it was revealed that the other party doesn't want to pay for the construction of the futsal court, which is an additional item, I think.
Ah.
And because of this, party A obviously doesn't want to, it's this question. So obviously because of this, Z Nation doesn't want to like continue because you're not paying me 10 million. So my understanding of all of this was that I was of the opinion that frustration would be applicable.
Frustration. Okay, I don't think. Sorry.
Sorry, because like it's like suddenly it's like how is he supposed to complete the contract if he doesn't have the money for it? So how is the contract not frustrated lah? I thought that was my line of thought.
Sorry, I cannot hear you. The last questions.
Sorry, my line of thought was basically, how is the contract not frustrated when
How is the contract not frustrated? Okay, I wouldn't think it's a frustration because, like I say, frustration, there are three elements. Number one, the contract becomes unlawful and impossible to perform. Number two, it's a supervening event. Number three, it's not a self-induced. So you see, number one, how can you say, because this question, I briefly mentioned about these facts. This question is a company make a tender, ask who wanted to help me to construct futsal court and basketball court. Then our client offer 10 million, if I'm not mistaken, 10 million to say basketball and futsal court only. But then when he make this offer, okay, this is ITT, A make ITT, B make offer, okay. But this, what we call A did not accept unconditionally. A never say, okay, good, 10 million for basketball and futsal. No. Instead, A say, hey, then you build additional badminton. This is counter offer. There is no offer, there's no acceptance yet. This is counter offer. Then when counter offer, B never say yes or no. B only say we can discuss it further. So technically, there's no form of finalized contract yet. Then they do. Okay, no issue. Then B even say, okay, I will buy material. A even provide a place for them to store the material. Then the issue happened when A asked B to leave the site. He said, okay, I don't need you to build the futsal court already. So now the question is whether there is a valid contract for A and B or not, because A and B never come into the finalized conclusion regarding the futsal court. Okay, my answer to this question is that yes, there is no formal contract. There's no offer acceptance for futsal court because basketball and futsal is settled. Now it's badminton only, so we focus on badminton. So why we say B have a cross of action against A is because B offered to say that if you want me to build the badminton, another 5 million. And what A answer is that A by conduct to say, okay lah, I give you a place to store this thing lah. By conduct is accepted already. So therefore we can sue. Because if you never agree, then why you give me the place? For example, I say I will do tuition. Whoever wanted to join, transfer 1 ringgit to me, for example. So you guys never say yes or no. You just transfer 1 ringgit to me. Okay, then don't you think that one is a acceptance already? So similarly to here also, you provide me a space, you accepted already, and I told you I will go and buy material also, you never stop me. I suffer loss already, I give consideration already. So acceptance can be go through by conduct. And now your question you're saying is a frustration. I don't agree. It's because number one, the contract is still valid. The contract never become impossible or unlawful, the contract is still can be carried out. Okay, and so I don't think it's frustration.
So for the element of impossible to perform, I think that's why I was thinking frustration, because Z Nation is literally, he cannot perform, it's impossible for him to perform because he doesn't have the money to continue.
Okay.
So is it that, that's why I'm like, how is that reasoning?
Okay, the impossible to perform, it means I want to perform also cannot perform in the way like World War or per se or something happen make me cannot perform. But in this case, it's not you cannot perform. It's just that the party don't want to honor the contract. Like the Z nation says, I never agree, I don't want to pay you. So the fact impossible to perform is not in that context, it's different situation. It's not like what you say, Nassau.
Oh, I see. Okay, thank you.
Okay. So another question, sir, can you please go through the Specific Release Act as a whole, particularly Section 11, 18, 20, and 21? May I also ask when each of the provision will be typically applied? Okay, I can roughly go through lah. Last time, this Specific Release Act is in my handwriting notes, but in the Word documents I never type inside because my time actually they don't ask that often one. But now I think they're getting more, they prefer to ask lah. But I think still okay. Why? Because you guys can bring in the Specific Release Act. My time we cannot bring in one. Okay. So Specific Release Act Section 11 do mentions in what situations the court will give you the specific performance. Number one, Section 11 the act agreed to done is in the performance wholly or partly of a trust, which means when it's a trust, the court may give you specific performance, ask you to perform. Number two, when there is no standard to ascertain damages, which means money is not good enough. I don't know how to ascertain the damages because, like I say, equitable is a very strong remedy. If you can get the money, just get the money. But because in this case, it's not easy to calculate my losses. I want not only money, then the court may give you. But again, please note that all this is just a factor. It's not a compulsory thing. And three, money is inadequate. It's not enough. Okay. And number four, reasonable presumptions that compensation is insufficient for immovable property, which means when it comes to property, the court may presume I not only want money, I want this land. But actually, in reality, you need to prove to the court that why this land so special. You only want this land. You don't want other land. Okay. So this is all the presumption or all the factor the court may consider to give you specific performance. On the other hand, Section 20. In what situation the court may not give you? Number one, money is adequate lah. Actually, it's the same as the one lah, but it's like just opposite lah. Number two, too many details, personal service and not suitable. How to say For example, the specific performance you want to perform is that A employee work for me 3 years, must go toilet at 2 p.m. B employee must come to office at 7 p.m. Which means you involve too many details and personal service. You wanted to control the person's freedom. This kind of thing the court wouldn't allow because it's a bit like infringement of human right already. Okay. And the terms are uncertain, which means when you want people to perform but the terms is uncertain, how to enforce, it will create more problem. And contract is revocable, means like the contract memang can revoke one revoke means cancel lah. Then why you want to specific performance? People have the right to cancel And the contract was made by trustee or breach of trust. Okay, which means the trustee go and make a contract, then cannot have specific performance, which means the trustee only is a temporary holder only They are not the owner They are just an authorized person Okay. And the contract was made by on behalf of the company or promoter. So it's like other people promise you punya, it's not I promise you. And continuous duty more than 3 years, which means you want to force people continue to do service for you 3 years, also like a bit like infringe human right And the subject matter cease to exist, which means let's say you say, hey, I want to buy this land, but this land no longer exists already. So then you cannot have specific performance understand? So this is 20. 18 is compensation. Okay, this one. The plaintiff can apply for damages in addition or in lieu of specific performance. So I think this means like not only you can claim for damages, you can also ask for specific performance, which means people may say, hey, you got specific performance already. No, I can ask for both or in lieu. In lieu means like in replace of. Okay. So if the court is decided not to grant a specific performance, the court can grant damages in lieu of SR. Actually, SR is what? Let me check. Section 18. Too long never study this chapter already.
specific relief, right?
Specific relief. The court decide not to grant specific performance, can grant damages in lieu of specific relief. Okay. Wait, let me see the section 18. Specific relief. Okay. I think maybe they means like other specific relief. Let me see. Wait, never mind. Later I check back my notes. What is SR? Okay. So third one, if the court decided to grant specific performance, but that is insufficient, is not sufficient to satisfy the justice of the case, the court can grant damages in addition to specific performance. Like I say, which means not only I can claim specific performance, I can ask for damages also. Okay. Then compensation may be awarded in such a manner as the court may direct, which means the court may also give more details how to perform the specific performance. Then, okay, the contract become incapable of specific performance, the court may give compensation. You see, the whole section 18 are more like they were talking about whether workable or not to give you specific performance or damages or interchangeably. Okay, so this is section 18. So 18. Okay, 21. So 21 is discretion of the court. So specific performance is discretion of the court, but not arbitrary, but sound and reasonable, guided by judicial principle and capable of correction by court appeal. So again, this is just want to mention that, like I mentioned just now, all those things just now we mentioned, it's just a factor only. You cannot tell the court, hey, it's land, you must give me. No such thing. The court can still decide whether they want to give or not. And then section 21, not to grant if unfair advantage over the defendant involves some hardship on the defendant. Like I mentioned just now, it may create more problem if you force somebody to do something they don't want to. And then the situation where more likely to grant, the plaintiff has done substantial act. The plaintiff losses in some consequence of a contract. Okay. So this is the thing. But this one a bit outdated idea because I do it when I seek for CLP quite long ago already. So I haven't got time to update it. Yeah. Okay. Anything else? Sir, in the prayer for contract, can we put declaratory order for injunction? Yeah, sure. We can put, and you must put if you want. If you don't put, right, we are bound by our pleading. So if you never plead, then the court cannot give you. So anything else? So if we don't see any questions, then we will stop here. Just now I think someone text me a case, right? Can you text the case again? I think Max something one. Later I will have a look and then I tell you what is my understanding on that. Is Max. Yes, I will post the video on the YouTube later. I will combine the two videos because just now had the interaction already. Okay, so we will stop here. The guys just now asked me the case. You post in the group, then I will check and get back to you. Okay, so all the best, everyone.